Yes, Mr. Eady.
Good afternoon. I've got a fair bit to get through, so I might have to speed up a little bit. But you will recall we were in Buttes, and you will recall that directly after posing the question and answering it at 789 to 1789 to 1790 in the electronic numbering, Lord Wilberforce cited two cases, Blad and Brunswick. And what if I understood it correctly, what the respondents contend is that Blad and Brunswick, neither of them support the wider principle, because the former is correctly seen as a conflict of law case, and the latter is about sovereign or state immunity ratione personae. And I'm going to take you very briefly to those two cases just to try and deal with that suggestion, but perhaps the more general dispositive point in relation to that suggestion is that Lord Wilberforce evidently didn't think so, because he cited them for the general proposition of principle that he set out. But aside from that rather facetious answer, Blad is in Bundle 1, Tab 12. In the manner of 1674 cases, it isn't entirely easy to read or get to the base principle. But perhaps for this purpose, the relevant parts are under the head note, the first sentence, lasting for about 5 lines, just to give you the context of it. So, Blad, who was the Dane that seized Blamfield's property.
This is Lord Nottingham's note, is it?
Yes.
Yep. Okay, thank you.
And we should see the preceding case, shouldn't we? Of which see the beginning before at the council board, see the preceding case and note, it says. It's a bit difficult to understand.
Well, my lord, can we get that? I'm not going to spend long on this, but just to show you the relevant bits.
Well, there is a quotation from it by Lord Wilberforce.
There is, and that is on page 1838 on the second page.
But presumably we're looking at it from more than the quote from Lord Wilberforce that we'd already seen.
Yeah.
Are we?
But my lord, I'm not. I was simply showing you where it came from. I'm sorry to take up time with that. But
well, thank you.
We've got Brunswick.
It shows that Lord Wilberforce can quote from a case accurately.
You were going to tell us what the case was about so that we could understand that it wasn't just authority for a narrow principle, weren't you?
Well, I was, but
Do you not want to?
You've got that from the first sentence, I hope.
I see.
Why isn't it conflict of laws in a sentence?
Because it involved pure, as you see from the quote that Lord Wilberforce did give in his judgment, it involved a pure act of state analysis, effectively. It concerned the Executive Act, the seizure of Blamfield's property on the high seas, and the refusal appears to be based on comity, for want of a better word, as one sees from the passage that Lord Wilberforce did quote.
Well, the result of the case was that it was effectively, as we would say, struck out.
Yes.
So
I'm sorry, I was unfair because you were taking us to the first sentence of Blad as being relevant. I'm sorry, Mr. Eady. Thank you.
Brunswick, which is the tab before,
Yep.
1827 in the electronic numbering. I'm not going to go through it in great detail, but if you could mark on this, we dealt with it in a little more detail on the facts in our case at 107 to 112 of our case.
Thank you. Yes.
And again, the facts are long and complicated, but can I try and summarise it in this way?
Yeah.
Charles, the Duke of Brunswick, effectively had his kingdom/assets placed under new management. And the new management was being carried out, first of all, by the Duke of Cambridge, who was an English subject, but he was then succeeded in the new management regime by William, the Duke of Brunswick, who was also an English subject and took over. That transfer to new management was effected by, if you will, a revolution in Brunswick, with the Diet effectively transferring power from Charles to William. And that was effected by an edict or bill, instrument, done by a combination of William, the Duke of Brunswick, and William IV, King of Hanover. And you see all of that from the first 2 pages of the report, 1827 to 1828.
Yeah.
And then the judgment of Lord Cottenham, the Lord Chancellor, starts on 1832, 2/3 of the way down.
Yep.
And you'll see the expression of principle in the final paragraph on page 1832.
Well, the whole question seems to me.
The whole question seems to me. And then if you read, if you would, to the end of the paragraph on the next page. So just for your note, whilst you're reading that, or when you finish reading that, if you go back to page 1830,
Yeah.
the master, you'll see about 1/3 of the way down, the respondent appeared, see 6 Bevan and so on.
Yes, yes.
And demurred. The master of the rolls allowed the demurrer. We've got the judgment of the court below. At authorities 30 tab 232, supplemental MS 263. I don't invite you to turn it up now, but it's of interest for the reason set out in our case at 111, which is that it demonstrates that the acts of which complaint were made took place abroad, in the sense of generally abroad, i.e. there were lots of acts, only some of which took place in Brunswick. Does that make sense? So it was not just within the territory of Brunswick. There were acts elsewhere, so property in Paris and so on.
Yes, I see.
Various acts in relation to that. So that appears tolerably clearly from
Right.
Lord Langdale's judgment in that case.
Right.
But you'll see the expression of principle back on page 1832 to 1833.
Yep.
And you'll see the conception, private versus sovereign, if I can put it this way. You see the number 18 just at the top of page 1833, just at the end of that short paragraph.
Yes.
Face of this bill, the allegations show that the acts could not have been done, were not done in any private character, but they were done, whether right or wrong, in the character of a sovereign of a foreign state.
Yes.
And then if you cast your eye down about the middle of the page, halfway through a line, there is the number 19, just on either side of that. The whole transaction arose from acts done in the exercise of rights of sovereignty claimed to be vested in those who were actors. And then you see in the paragraphs from halfway down the next 2 paragraphs there, that there was support for the revolution in effect. From the defendants. And then 5 lines up from the bottom, 6 lines up from the bottom, alleges that those acts are acts of persons claiming to have the right so to act by virtue of their sovereign authority. And then in the 2 lines just before the final paragraph of the Lord Chancellor's judgment over on page 1834,
Yeah.
about 3/4 of the way down the page, if that be so, do you see that line? So 3 lines up from the final paragraph of his judgment. That be so, it does not require another observation to show it has not been doubted that no court in this country can entertain questions to bring sovereigns to account for their acts done in their sovereign capacities abroad. So that's
So there the language slightly trips into immunity, doesn't it, Mr. Eady?
in the sense of immunity ratione personae.
Yes.
My lord. Yeah. Well, yes, although it's my respectful submission, if one reads the judgment as a whole, it is both. It is both ratione personae and materiae.
Was the relevant sovereign actor a party to the action? He was, wasn't he?
Yes, they were.
Well, the King of Hanover was a defendant.
He was.
It can't be in state immunity because they said that he could be sued here because he was here in his private capacity.
And he was a subject of the Crown.
The subject of the Crown.
So his position was complicated.
Jurisdiction existed, isn't it? I mean, jurisdiction to serve the writ.
Because he was hit.
That's the only relevance of his being here in his private capacity.
Yes, but they also play. I mean, I'll have to check it, but they also place reliance upon the fact that he was a subject of the Crown, and there was some analysis of whether the Duke of Cambridge, who was plainly here, plainly wasn't sovereign abroad, would have been in the same position.
Yes.
Where do they say that the Duke of Cambridge could have been sued? Yes, it's on the last page, just above 27. The inclination of my opinion certainly is the Duke of Cambridge could.
Yes.
And it could not have been sued. It could not have been sued.
Yes.
Presumably an agent of the sovereign.
Yeah, because it would involve
Well, or because the act that's being
subsequent period when it's when the Duke of Cambridge was king that he's being sued in respect of, is he? The period when he was king.
I'm not sure the Duke of Cambridge became king.
Well, it does say. Well, if you look on page 1834, about a third, just more than a third of the way down, when the Duke of, I beg your pardon, no, it's Duke of Cumberland, my fault.
Fine.
Of course, it was Duke of Cumberland who became King of Hanover.
Well, I suppose one possible.
Duke of Cambridge then
things
accounted
have
to
moved on a
him.
bit since 1848.
Duke of Cambridge accounted to the King of Hanover. He was his agent, presumably.
He wasn't. He can be taken to be that. But if you, my respectful submission is, if you read the judgment of the Lord Chancellor,
Yes.
and the expression in particular of the principle that Lord Wilberforce relied upon,
Yes.
it is authority for the proposition that
Yeah. The Duke of Cambridge was acting under the authority of the decree of William IV, King of Hanover.
yes, but the principle I was relying upon, 1832 to 1833, is cast on the basis that the focus of it is the act of the sovereign,
Yeah, it's paragraph 18, really.
just above paragraph 18 and paragraph 18. Or I think it's page, it should be.
Page, isn't it?
Page, sorry, yes.
But 1832 to 1833, William IV was sovereign, wasn't he? William IV was King of Hanover in 1832 to 1833.
He was also King of England.
Yes,
Yeah.
but he was King of Hanover.
Which is
Just
the point.
they had the Salic law. That was the point.
So they never ended this case again.
So Victoria couldn't become Queen of Hanover.
His appeal never come to an end.
Had to go to one of her uncles.
My lord, yes.
Some of us can remember our schoolboy.
Right, I'm struggling.
Some of us think it's time to get on to the next case.
Well, as long as you've noted where that principle is, then I'm very happy to get on to the next case. Just as, can I invite you to note, just before I do, in Lord Lyndhurst's judgment, the emphasis on the facts that all the acts were done abroad.
Yes.
Third line of that. Lord Brougham, to the same effect, about 7 lines into his judgment on the top of the next page, 1835.
And Lord Campbell agreeing, and then in the final paragraph of his judgment, saying the Lord Chancellor would not grant an injunction against the French Republic marching an army across the Rhine or the Alps. So you pays your money and you takes your choice.
Yes. And saying, I don't want to reopen the debate about the status of the Duke of Cambridge, and saying the first paragraph on that page had the most serious doubts about the point they were all assuming as a postulate that the Duke of Cambridge could have been sued for the matter. In other words, it wouldn't have had a problem with, even a particular problem with sovereign immunity at that point, ratione personae. Serious doubts upon that point, because even if he had been sued, it would equally have been a matter of state. The same questions would have been submitted to the Court of Chancery, namely, and so on. So he's focusing on the subject matter of the dispute, the subject matter of the issue.
Yeah.
So it's really that makes it, as it were, a case about immunity ratione materiae rather than personae, we submit. And that's how it was taken by Lord Wilberforce in Buttes.
Okay. I echo what Lord Clark said a minute ago.
Yeah. That's it on that. One other of the cases it's perhaps worth just gently referring to in the context of Lord Wilberforce's judgment is Princess Paley Olga.
Yes. Where do we find that?
Bundle 9, tab 69.
Thank you.
Page.
Sorry, MS 4514. So sorry. And the passages for this purpose, again, I should take it quickly just to deal with it. In the, you see, this is an expropriation case, effectively, shortly after the Russian Revolution. Lord Justice Scrutton, in the Court of Appeal, and they disagree with the first instance judge, Mr. Justice McKinnon, on this point, which is the act of state point. And you see at the bottom of 4519,
Yes.
there is, however, a third defence which he rejected, which I think should also succeed. Act of state into the validity of which this court will not inquire. And then you'll see that there's an extensive citation before concluding that that was a ground for shutting down the claim from all the cases that we're now well familiar with, Otgen and Rico in America, and Luther and Sagal. Same point in Lord Justice Sankey. His judgment begins at 4521 at the bottom. You'll see his summary of the nature of the arguments at the top of page 4522. Note in the second line 1 that the seizure of the goods in 1980 was an act of state, which transferred property from her to the state. And in the first full paragraph on that page, recording that Mr. Justice McKinnon effectively had concluded that that shouldn't be allowed as a ground of objection, but the Court of Appeal disagree. And then you see at 4523, after the extensive reference to the evidence, final paragraph on 4523, the decree of August the 14th, 19 was signed and so on. In other words, it was a decree of the local Petrograd Soviet. Admittedly, it had no legislative effect, but in fact the occupation of the house and furniture was a seizure by the state. So we're not dealing with, remember Lord Wilberforce, in his narrow conception of it, was legislation within the territory of foreign state. Here we're within the territory of the foreign state, but it isn't legislation. Indeed, if
Well, he cites it in support of his narrower proposition.
Yes, he does, my lord.
And you're arguing for the wider.
I'm arguing for both. We've got a narrower and a wider. But we respectfully submit that in its narrower version, it doesn't necessarily need to be confined either to the territory of the state or to legislation. So for this case's authority for the proposition, it doesn't need to be legislation. And indeed, you'll recall that Underhill and Hernandez itself had nothing to do with legislation. It was a claim for false imprisonment. So a pure executive act, and here we're dealing with a pure executive act in the same way.
Yep.
And then the citation or the quotation of principle from Opgen we see being relied upon at the top of page 4525, second line, every foreign state is bound to respect, will not sit in judgment, and so on. And then the conclusion on this issue from Lord Justice Sankey is in the first full sentence on page 4526, in these circumstances. And then Lord Justice Russell deals with it much more shortly, 4532, the first full paragraph.
But that doesn't support the proposition outside the territory, does it?
It doesn't deal with that.
No.
It deals with,
No, it's a conflict of laws point, effectively.
it deals with, well, it's a bit more than a conflict of laws point. Well, it is a base, perhaps, but it's act of state, pure and simple, within the territory, as it were.
Right.
That's the proposition for which we rely upon it. But Brunswick, as I indicated, Brunswick does go not merely into Brunswick, but elsewhere as well. Hence the repeated references to abroad and so on. So, again, we've dealt with that in some detail in the case. That was my lady.
Very difficult. With Brunswick, one doesn't know where the German Confederation, the Diet of the German Confederation sat. That's the one thing they don't tell us.
No, that's true. That's true. But if you go back, I'm not
No.
going to irritate Lord Clark by going
I know
back
there
to
was
it
the
again.
Paris business.
But the facts is Paris, and there's
But he seems to have won in Paris. He actually recovered monies, so he presumably wasn't complaining about Paris.
Yes. Well,
I think, perhaps you could come back to it at some point, but what was it he was complaining about that took place outside Hanover, is the question.
okay. Well, let me.
I think he was complaining about the Diet, the decree of the Germanic Diet,
And the handling of all his property, wherever it may be.
in right of the Holy Roman Empire, or a successor to the Holy Roman Empire.
Right, but there were a series of complaints. The property wasn't restricted to Brunswick. The actions in relation to the property weren't restricted to Brunswick.
Yeah, I see that.
The fons et origo of it all was the Diet's resolution that affected the new state of management, as it were. But the series of complaints existed elsewhere. And again, if one goes back through, I don't want to labour the point, but if one goes back through Lord Wilberforce, one sees references to abroad, acts abroad.
But I suppose he was complaining about the instrument in writing signed at St James's Palace, deposing him as well.
Effecting the change.
Yes, affecting the change.
Yes, it's very well. Perhaps the point can be put negatively, as it were. It's very difficult to confine the nature of the complaints to Brunswick alone.
Yes.
So my submission, I'll come back to it, is not confined to territory and not confined to legislation. And the reason not confined to legislation is, first of all, a reason of principle. Why would you so confine it? Legislation in your own territory is simply the paradigm expression of sovereign will. It doesn't limit the concept of sovereign act or sovereign will. Where would the distinction of principle for saying that one type of sovereign act is covered but the other isn't? It's just a paradigm example. But there's also no basis for so limiting it in authority, although the paradigm example has often been given, state within its own state legislating for its own property. But we've seen a series of cases which do not involve legislation. Princess Olga was the decree and so on by the local Soviet. The three cases, or the cases I've just gone through, Carr and Fraser's Times that Lord Wilberforce refers to, Luther and Sago, same thing, legislative and executive acts of the government of Russia is the way that Lord Justice Warrington puts it in Luther and Sago. And indeed, Kuwait Airways, it might be thought, is a pretty decent example. They considered ultimately that the exception applied, but here we're dealing with the very conception of the concept itself. Is it limited to legislation? Well, no view was the taking of the planes in Kuwait an act of legislation. My Lords, I've referred on a number of occasions to UKOS, and just so you see the nature of the analysis, I'm not going to go through it in any great detail, but can I just try and identify some paragraphs that may be of interest when you come to consider the matter? It's Authorities 1, tab 3, MS 1588. And it's a long judgment analysing both the conception on which the Court of Appeal in Belhaj placed considerable reliance, analyses both the conception of foreign act of state and the limitations of the doctrine. The key paragraphs are between 40 and really at the end of 137, so there's a long section, but the early case law is identified and worked through from 40 onwards. So one sees, if you go to 1607 in the MS numbering, you'll see the reference to Blad, the reference to Hanover in 40, all the American cases in 41, Princess Paley Olga in 42, Buck I've already referred you to in 43, Nissen and Attorney General. You don't need to perhaps to worry about that terribly. That's a leading case on Crown Act of State. And was one of the authorities that doesn't appear to have been cited to my Lords in Shergill. It doesn't terribly matter perhaps for our purpose, but it's a big authority on Crown Act of State. Then Butts is given the treatment in the following paragraphs. And we respectfully agree with all of this analysis. 53 is Pinochet, and again I've taken you to the quotes in 53 and 54 from Lord Millett and Lord Phillips.
Yeah.
Kuwait is then dealt with in 55. And then 65 and 66 are perhaps of some interest. 65 deals with the political embarrassment principle, whether it stands for that. And then 66 is perhaps their attempt to drag it together as a...
Yeah, you've taken us to that.
Yeah, as an overarching principle.
Yep.
I'll see, just so you note, the reference just above C on that page 1616. The various formulations of the paradigm principle are apparently wide and prevent adjudication on the validity, legality, lawfulness and acceptability or motives of state actors. Form of immunity, ratione materiae, closely connected with the analogous doctrines of sovereign immunity. Again, we agree with all of that. That, I was asked earlier on about effectively the Kirkpatrick notion, what do you have to be covering, what do you have to be dealing with. That set of concepts, validity, legality, lawfulness and acceptability, is very much an echo of Lord Wilberforce in Butts. Perhaps we could write next door to that, see Lord Wilberforce in Butts 1719 by the letter B, where he groups a similar set of concepts all together to try and define the reach of the thing.
Thank you.
My Lords, then Shergill, Authorities 1, tab 1. Can I make just a couple of initial points without in any sense seeking to disagree with the praise heaped upon the judgment by the Court of Appeal in Belhaj? It was, as my Lords, or some of my Lords will recall, I think my Lady wasn't in Shergill. But some of my lords will recall, Shergill was not a case about foreign act of state. You may say mercifully, but it wasn't a case about foreign act of state, nor was it a case about Crown Act of State, which no doubt explains why Nissan wasn't cited. It was about religious trusts in England, and the issue of non-justiciability was considered in a different context, the extent to which courts will sit in judgment on issues of religious belief, doctrine or practice, in Shergill itself surrounding Sikh spiritual succession. That might be thought the context was a little different from the context that we're dealing with here. There was, if the citation of cases is to be believed, there was no consideration of Nissan, Crown Act of State point. There was no consideration of Kuwait Airways, nor was there consideration of the Court of Appeal's judgment in UKOS. And again, I make no complaint about that. It's hardly surprising, given that the case did not raise or concern issues to do with foreign act of state. But it does perhaps bear noting, at least. So far as Shergill and its correct and proper analysis is concerned, again, very broadly and with respect, we agree with the analysis of this case of the Court of Appeal, who, as you will recall, treated it as part of their analysis of the rationale that underpin foreign act of state. So the relevant paragraphs in their judgment are 56 through to 68.
Thank you.
And they did not, in a nutshell, consider that the rationale or principle that underpins foreign act of state was limited to judicial competence, if I can put it that way. There was a wider rationale which they found to be based in sovereign equality, and I've gone through the rationale. I'm not going to go through
Yes,
it
you
again.
have.
And indeed, as I've also made the submission on the back of paragraph 67 of the Court of Appeal's judgment in Belhaj, that they didn't think that that's what you were doing in Shergill anyway. So Shergill itself, if you go, first of all, if you would, to 39...
I mean, the Shergill was a domestic case involving effectively the argument that based on judicial competence. It wasn't necessary for us to consider the other aspects. That's your point.
My lord, exactly
Yeah,
so.
I understand.
And if you go to 39 and 40,
Yep.
which is where you come to the conception of Butes as a political... We've been back around this house a little bit this morning, but analysing effectively the judgments in Butes, or Lord Wilberforce's judgment in Butes about as being solely about political matters.
Yeah.
No doubt there are strong strands of that within Lord Wilberforce. No one is disputing that proposition. And it may even be that the explanation of Butes could, if necessary, on its facts, be so confined. But we've seen already from the analysis of Butes that what Lord Wilberforce was doing was to identify a broader principle. And not merely was he identifying a broader principle, but he was applying it in the context not merely of political questions in the sense of transactions between states, but was looking more broadly to acts of the sovereign authority committed by virtue of the sovereign authority of foreign states abroad. That was the principle that he espoused. And what, if I've understood it correctly, is being done in 39 and 40 is to deal with a very specific conception of non-justiciability that the Court of Appeal had adopted. So you'll see in 39 the approach that the Court of Appeal had taken. And the court in 40 is analysing Butes for the purpose of dealing with that conception. And they concluded in 40 that it wasn't that broad. And I've made my submissions on Butes. I'm not going to go back to that, but my respectful submission is that it stands for a broader principle, and that the facts of Butes also took in the allegations of conspiracy and the unsuitability of the courts getting dragged into that sort of issue for the purpose of the resolution of a case before it. But the analysis then of broader principle sits between 41 and 43. And again, if my understanding is correct, what the court is trying to do here is not, as it were, to solve all the ills that might arise in this area, but is rather to sketch basic fault lines, as it were, and to analyse the concepts at a tolerably high level of generality for the purpose of informing the nature of the issue that actually arose in that case, which is whether or not the Court of Appeal had applied the right approach to non-justiciability on grounds of lack of judicial competence in the context of a religious matter. And the court held no. But even taking them on their face, and as I say, the Court of Appeal in Belhaj considered this a useful and helpful summary of some of the basic concepts that are in play in this area. The conception that we would respectfully invite the court to adopt in relation to these paragraphs is the one that I slightly flagged earlier. You pick up Act of State doctrine in the fourth line of para 41, but simply there refer to it. You then break down the categories of case and seek to provide, as it were, a scheme of analysis, a broad twofold scheme of analysis into which they might fall, perhaps more than twofold, given the complexities of some of the issues that are raised, but a broad scheme which draws a line, as it were, between 42 and 43. And in 42, you deal with, as I said earlier, the paradigm cases are the non-justiciability of certain transactions of foreign states and proceedings in Parliament. That's the Hamilton and Fayed sort of example, and Preble. You say that cases in the category are rare, and perhaps the reason the categories are rare is because they by and large illustrate that there is a principle, which is the one that we advocate. There is a principle that says even if you would otherwise have a claim as of right, so you could sue for tort in a domestic court where you could make good jurisdiction by having served the right person in the right place, even in that sort of situation there are a set of principles which cut out from the court's proper examination particular types of issue. And that's why I highlighted earlier on the penultimate paragraph of 42. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it's necessary to do so in order to decide some other issue, which is itself unquestionably justiciable. And that's precisely, we respectfully submit, the nature of the Foreign Act of State principle, as conceived by Lord Wilberforce in Butes. And the cases that then follow in 43 are the rather different sort of cases where you can't find a domestic foothold because you're in the rather more amorphous territory of public law and you're trying to use it to control executive action, and there are well-known limits on that. So those are the submissions we make in relation to Shergill. Firstly, Court of Appeal respectfully right that it doesn't stand as authority for the proposition that Butes is to be confined simply to a principle about judicial competence, for the reasons they gave when they were analysing the rationale of Foreign Act of State. It didn't arise anyway. But even if you take 41, 42 and 43, the broad schematic analysis that the Supreme Court sets out there, even if you take them on their face, the proper location for Foreign Act of State lies within the distinctive feature reasoning of 42. And so the Respondent's case is that Foreign Act of State can't work as a doctrine, but where it simply doesn't apply at all, where the claim is as of right. And that appears broadly to have been the conception of Mr. Justice Leggett at first instance below in the Rahmatullah case. And we make, by way of summary, 3 short points in relation to that, if I may. First, Foreign Act of State has been developed and applied primarily in the context of claims as of right. C, for that purpose, Underhill and Hernandez, a claim for false imprisonment and assault, Butts, defamation, Kuwait Airways conversion, UKOS enforcement action, Oppenheimer, UK national dealing with his UK tax liability, and so on. Second, the cases and the aspect of non-justiciability to which reference is made in para 43 of Shergill have limited bearing on foreign act of state as it arises in the current cases for the reasons I've just indicated. Those cases are all very different. They're all to do with finding a foothold in domestic law for the purpose of challenging executive action, effectively. That was what CND was about. That was what Al-Haq was about. CND, of course, was about treaties. Abbasi is referred to, but perhaps the big point to make in relation to Abbasi, and it's on a slightly different issue, but the big point to make in relation to Abbasi is that the court there very deliberately held back from making any determination about the unlawfulness of conduct of the United States, as is evident from 107 of their judgment. I'll come back to Abbasi in due course, but that was the very point that was being made about Abbasi in CND. See Lord Justice Simon Brown in CND at para 29, analysing what Abbasi was and wasn't doing. But thirdly, and in any event, by its nature, the application of foreign act of state as a principle is not delimited, we submit, by the way the claimant chooses to formulate its case. It is the nature of the foreign state's act that is important, not the precise formulation of the claim or the manner in which the claim is brought. So it can't and shouldn't make any difference in this respect whether one is dealing with a claim for damages. As we know, lots of the Iraqi claims currently going through the courts, personal injury claims for damages. We also know that any number of them are going through the courts as claims for judicial review, and the subject matter tends to intertwine. It cannot be a form of action distinction. And again, one gets a bit of a flavour of that from the case about where the government of Equatorial Guinea were challenging, trying to get money back for having put down the attempted revolution over there, which my Lord Clark may recall, the Basogo and Logo case, which you have in the bundles at bundle 5, tab 42. I'm not inviting you to turn it up now. But those were tort claims, but nevertheless, and therefore as of right, but nevertheless shut down, in this case for the slightly different reason, which was that the government itself was using, the foreign government itself was using the courts for the sovereign purpose, if you will. So, my lords, that's what I wanted to say on the basic conception of foreign act of state and on Shergill. Can I turn then to the limitations? Just before I do, I meant to say, as you came back, I was asked this morning about how it might all work in the context of criminal proceedings. And my lord, I don't wish to be seen overly to be ducking it, but I'm going to do exactly that. And I'm going to do exactly that because criminal process, criminal investigation, criminal decision-making in terms of prosecutions raises fundamentally what might be thought very different issues. You know that there are different statutory rules in some situations. In other words, statute has intervened to prescribe certain ways in which you prosecute and deal with certain criminal offences, including torture. And of course, statute trumps any common law principle anyway. But the reason that I'm particularly cautious about getting sucked into any position on behalf of government or generally is because there is already, as my lords will be aware, I think those are aware, there is an ongoing criminal investigation anyway in relation to some of the matters that are the subject matter of the Belhaj litigation. And so I hope you will understand that the ducking is not because I want to avoid a difficult point of principle, but for good and sensible reason. I don't want to be committing to any position or trying to predict what arguments might or might not want to be deployed in that context. But in any event, my fundamental submission of principle is, irrespective of what the position is or might be, under the criminal side, we're here dealing with trying to ascertain what the limits are of the civil principle. So to the limitations, and a philosophical note at the outset, if only to give you the reference to the Court of Appeal's Platonic references to silhouettes and the concept being defined more closely by its shadow. That is at 115. To some extent, there is real force in that. That's 115 in UKOS, 1636 in the electronic numbering. But the limitations have become of obvious importance in terms of the conception of the principle. I make one initial point as well in relation to the ECHR limitations. Again, if only for my lords and my lady to note, our position on foreign act of state does not, we respectfully submit, require a development of the common law inconsistently with the Human Rights Act. I've already made the point that the Human Rights Act was not engaged for the relevant period of Mr. Rahmatullah's custody in the hands of the United States, as Mr. Justice Leggett found in the Al Sadoun litigation, Authorities 2 tab 19, paragraph 136, electronic 2127. And the ECHR is not even alleged to be engaged in the Belhaj litigation. And so all of the reliance upon the ECHR and other international causes of action just simply don't arise. And we also respectfully submit that the reliance that appears to be being placed on the El Masri case, which you have in Authorities 1, tab 2, I don't ask you to turn it up now, but we respectfully submit that all of that reliance is in truth misplaced. Because there, the European Court went to great lengths to emphasise that it was considering the imputability to Macedonia of alleged US acts carried out in the presence of officials of Macedonia within the territory of Macedonia. That's paragraph 206. And we don't suggest that foreign act of state applies in relation to acts of foreign states in UK territory, where very different considerations would apply. So on the limitations that have been acknowledged in relation to the principle of foreign act of state, some of them we can sweep away tolerably quickly. The commercial limitation, not engaged, analysed in UKOS if you want it at 92 to 94. Judicial, again, not engaged. See UKOS 73, para 73 to 91. And again, the rationale for that limitation, to come back to an exchange I had with my Lord Mance about, isn't it rather odd that judicial can be an emanation of the state this way around, but not the other, if that makes sense. It was a kind of renvoi point. But in relation to that, could I invite you just to note UKOS 87, don't need to turn it up now, but UKOS 87, which explains the rationale for the judicial limitation as flowing from a series of rather separate principles. So those can be swept away, and statute also can be swept away. So one is dealing, first of all, in terms of the relevant limitations with, firstly, the Kirkpatrick limitation. We've dealt with that in our case at 127 to 133, and again in our response, paras 66 to 81.
66 to 81.
66 to 81.
Thank you. Yep.
In essence, what that exception is doing is to draw a distinction between, to use a conception of the Court of Appeal in UKOS, between referring to acts of state and proving their occurrence if disputed as an existential matter, on the one hand, and on the other hand, asking the court to inquire into them and consider there, and then you can put whatever form of words you want after this, but you've seen the various collections of words in 66 of UKOS and by Lord Wilberforce at 933 of Buttes, validity, legality, effectiveness, unlawfulness, wrongfulness, whichever series of words you want. And I've made our position clear already in opening. No doubt there will be cases in which there are really difficult issues to be solved. And Kirkpatrick itself, it might be thought, wasn't a bad one. It was an illustration of a difficult case. The extent to which you need to get sucked into bribery allegations for the purpose of challenging the effectiveness of the contract. But here we are simply not in that territory. For the reasons I took you to earlier, Court of Appeal in Belhaj, para 76, essential foundation that they should rule on the legality, and then the analysis of the various causes of action. Mr. Justice Leggett in Rahmatullah at para 39. And the core submission we make in relation to this part of the case is that the Court of Appeal in their analysis of it, which, just to remind you, is 70, sorry, wrong volume. Yeah, 69 to 80 of the Court of Appeal's judgment.
69 to 80.
69 to 80. If you take it briefly by reference to those paragraphs. See, they analyse Kirkpatrick first at 70 and 71. They analyse Sharon and Time at 73. And then the key part in terms of the analysis of principle is really in 74. That's the guts of it. And that was the passage, I think, where I invited you to put 66 and 109 next door to the paragraphs from UKOS. And that, it might be thought, that sort of approach sits tolerably comfortably, even if conceptually it might be a little different, with the point that Lord Wilberforce was making in Buttes about ancillary versus at the heart of the case. It also mirrors the approach to be found in international law and in international dispute resolution. Can I just go, or can I give you two sources for that? The first is the quote from the Nauru case, International Court of Justice, ICJ case, Nauru. But in our case, at 131, you've got the quote without needing to turn it up. I just invite you to go to our case at MS 137. It's para 131 of our case, just to save me having to go there. So that's what the ICJ said in Nauru. And then if you go to the East Timor case, which is in bundle 16, tab 110, MS 7026.
Thank you.
And the issue one sees identified, if you go to, just to give you the flavour of the facts, just go to paragraph 11 on page 7038. Bottom of the page, 7038, paragraph 11. And then if you turn over the page to para 13, you'll see that there were then some internal disturbances in 1975. The Portuguese then leave, and Indonesia comes in and occupies, and it's remained under Indonesian control since then. As you see from para 13. And then what happened was that Australia and Indonesia then entered into an agreement for the purpose of determining who should be able to exploit the mineral resources on the continental shelf between the south coast of East Timor and the north of Australia, as one sees from para 18. And the upshot of all of that international negotiation was a treaty, as you see from the final sentence or two of para 18. So that's the background.
Yeah.
And it's Portugal who make the complaint at para 19, first sentence. And then Australia say, well, hang on a second, the problem with that is that you have to rule on the rights and obligations of Indonesia if you're going to determine that complaint. And one sees the nature of the issue identified at para 23 on page 7048.
Really, the first sentence of 24, is it?
Yeah, it's 23 and then leading in, exactly. It's the monetary gold principle. I'm sure my lords come
thank you.
across it before.
Have now. Yep, thank you.
And so we respectfully submit that the approach that we've already seen is mirrored in international dispute resolution in that way.
It is said that this is simply a decision about the ICJ's jurisdiction, Mr. Eady.
It is, and our answer to that, my lord, without trying to develop it at any great length, is to be found in our response document at paragraph 64, where we make the point that it applies to other international courts and tribunals.
Which paragraph?
64, my note says. It is, 64. And we've referred there to a terrifying tribunal of Professor Crawford, Professor Greenwood, and Gavin Griffith. Oh, that's not terrifying for my lady, but it would be terrifying for me.
Oh, I don't know, they quite terrified us when they used to appear in the House of Lords.
Yes. But so of broader application is the short answer.
But isn't all public international law jurisdiction dependent on being conferred by agreement?
My lord, it is, but so is the doctrine of sovereign immunity, effectively. I mean, you've got similar underpinnings. I'm not making a great big point of this. It's just I'm just saying that it's reflective. The position that we espouse is reflected in international law.
Yes, I follow.
And the problem is that you can, if you say foreign act of states it doesn't exist, carry on regardless and rule on whether or not America tortured Mr. Rahmatullah in the 10 years that he was in their care. You end up in a place that's effectively overrides that consent, overrides sovereign immunity, and is objectionable on sovereign equality grounds for all the reasons I've gone through. And so far as this Kirkpatrick limitation is concerned, it may just be worth going very briefly to the Kirkpatrick case itself. It is in bundle 22. Sorry, forgive me just a moment. Someone get that. 172, I'm very grateful, thank you. 172. And just by way of note, here one has had a short exchange with my Lord Sumption this morning about the American conception of act of state, and you see the nature of the discussion that we had this morning on that, perhaps reflected in page 8984 under capital Roman 2, some evolution in the conception of it. And a reference to the Sabatino case that you've seen that you also have in that same volume of the authorities, which is helpful. But for this purpose, in terms of the conception of what needs to be, where the dividing line lies, if you go to 8986, just to try and identify the principle, about halfway down the page, act of state issues only arise when a court must decide, that is, when the outcome of the case turns upon the effect of official action by a foreign sovereign. When that question is not in the case, neither is the act of state doctrine. That is the situation here. So that's the way they cast the principle in that case.
And the citation of Underhill is on the left page is the closest analogy among the cases cited.
Yeah.
To the present issue.
Yes. And again, I'm a little cautious about going too far down the American conception of foreign act of state line for the reasons that I indicated in the exchange I had with my Lord Sumption this morning, because it's perfectly plain, in particular from the Sabatino case, that to some extent there's been a movement away from Underhill and conceptualising it more as a division between the various limbs of the American constitutional setup. So more respect, as it were, for the foreign affairs freedom of the executive, effectively, is the way they've tended to analyse it in Sabatino. Sabatino, for your record, I wasn't going to go through it, but Sabatino, for the record, is in 178 of the same bundle.
So, whatever the reasoning, Lord Wilberforce thought that the result was significant.
Yes. And that's ultimately where one gets to in relation to the American cases in Butte, is to the short proposition that Lord Wilberforce, entirely understandably, went to America for the purpose of seeing the learning there, took some inspiration from it, did not purport to align ours directly with theirs in terms of the explanation of the basis or rationale for it, but was concerned, as my Lord Mance indicates, but was concerned that everyone should pretty much end up, if possible, in the same place. Whatever route to the end was used, it was important, particularly given the nature of the doctrine and its sounding in terms of echoes on the international plane, that domestic or municipal authorities and courts should not be on too different a page in that respect. But, my lords, we say there's a short answer to Kirkpatrick, and the short answer is the one given by the Court of Appeal. Here they have to rule on the legality. It's pure and simple. My lords, the next question is whether there is a territorial limitation, extraterritorial limitation. And again, we've dealt with that in our case, if I can give you just the paragraph references, at 134 to 141 and 177 to 190. My submission is that foreign act of state is not confined to the acts of a foreign state done within its own territory and extends to acts outside, subject only to the limitation of being done in the United Kingdom. And so far as that is concerned, the matters that we rely upon in support of that proposition are that the limitation confining it to acts within own territory, that's two broad submissions, one, not supported by the cases, two, not appropriate in principle, but not supported by the cases, as the first one, no such limitation appears to have been formulated in the early cases on which Lord Wilberforce then relied. Blad, Duke of Brunswick, I'm not going to go back and reopen that set of issues, but at least on one conception of them involving acts outside. And again, at least on one conception of Buttes, the same applied. Of course, one can tie bits of it back into the territory, but there was a broader allegation of conspiracy. Look at all the issues that he identified in point number 2 on whatever page it was in the judgment that I took you to earlier dealing with conspiracies. Perhaps to be noted that the Court of Appeal in the Kuwait Airways case, can I give you the reference without inviting you to turn it up now? The Court of Appeal in Kuwait Airways at para 319, that's in bundle 6, tab 47A, MS 3502, said this: whether the sovereign acts within his own territory or outside it, there is a certain class of sovereign act which calls for judicial restraint on the part of our municipal courts. This is the principle of non-justiciability. And that very much echoes, we respectfully submit, all the references that one has running through Buttes to abroad, 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 abroad. So far as UKOS is concerned, they also considered that it was in principle capable of extending outside and wasn't subject to a principle that simply restricted it to acts within own territory. Bundle 1, tab 3, for this purpose, paragraph 68 on MS 1616. See how they put it in the second or third of the sentences of 66. It would seem that generally speaking the doctrine is confined to acts of state within the territory of the sovereign, but in special and perhaps exceptional circumstances, such as in Buttes itself, may even go beyond territorial boundaries and for that very reason give rise to issues which have been recognised as non-justiciable. And then they revisit the same sort of point in 115, para 115, on 1636. Where they note Lord Hope's description of it and then say the English courts will not adjudicate upon a call into question any such acts, various modern formulation of the doctrine at the highest level, but it perhaps needs to be understood as qualified by Lord Wilberforce's 2 insights in Buttes, that his principle of non-justiciability can also extend beyond international boundaries, and the principle is one of restraint rather than abstinence.
Sorry, that was 105?
That was 115.
115, right.
Para 115 on 1636 on the electoral. And then the final of the cases to note.
Where does 115 deal with rejecting the extraterritoriality
My lord,
exception.
sorry, it's between C and D.
Can also extend beyond
Oh,
international
yes.
boundaries.
Yes, you see that,
Thank
qualified
you.
by reference
Yeah.
to Lord Wilberforce. And then Noor Khan, I took you to earlier, I don't invite you to go back to it. But nothing turned on the location from which the US official might have been piloting the drone, and nothing turned on where the drone struck. The allegation was, as you'll recall, that the drone struck in Waziristan. True it is that, as the Court of Appeal noted in the Belhaj judgment, the point wasn't raised directly there, but that we respectfully submit doesn't matter terribly. Nothing turned or appeared to turn on precise location, so far as that's concerned, of either the strike or where the missile itself, or where the piloting was going on, or where the missile itself struck. And it might be thought also, to lead into the second of my submissions, which is it cannot be right in principle for there to be a territorial limitation. The Noor Khan case isn't a bad illustration of that difficulty. Take the reasoning of the Court of Appeal and assume it otherwise to be correct, which we invite you to do. It would have been just as great an arrogation of power and just as difficult and just as problematic for the English courts to sit in judgment on the acts of the US wherever the piloting had been done and wherever the strike occurred. Mr. Justice Leggett attached significance to the fact that Noor Khan was a permission decision, and so technically it was. But the difficulty with that as an explanation or as a way of downgrading or diminishing the importance of the case is that it was a permission decision which arose in effect as a substantive argument on the merits of the case that was being advanced by the claimant, at least in relation to that part of the thing. And moreover, as the Court of Appeal specifically noted at the end of their judgment in Noor Khan, they gave permission specifically for it to be cited as a precedent.
Yes.
Which was necessary and important. And that was done at, I think, at our invitation from memory. But so, cannot be right in principle. The reason for that, I submit, is that the underlying rationale of foreign act of state, namely that English courts cannot sit in judgment on the lawfulness of sovereign acts of a foreign state, is just as engaged, perhaps if not more so, when a state is acting outside of its territory. Sovereign equality, comity, all the practical problems identified, all apply with equal force to those sovereign acts. And the submission is therefore that where the rationale is engaged to that extent as it would be, and where the point of distinction really doesn't make any sense in relation to a pure territorial limitation, the principle should apply where the rationale so demand. And on a slightly cherry-picking basis, we have cited Mr. Justice Leggett at 178 of his judgment, where he said he would have held, had he not reached the view he did on Shergill and all matters associated with that, he would have held that the need to abstain from adjudication was just as great, as he put it, inside and out of the territory of the foreign state. And one can test the same point in a slightly different way. If I'm right that foreign act of state has very similar underpinnings to the doctrine of immunity, then we can test it by reference to those principles. State immunity ratione personae doesn't have any form of territorial limitation. You can't, a state is perfectly entitled to claim its immunity irrespective of where it acted. And so although, of course, it is right that some of the expressions of principle Lord Wilberforce himself in his narrow conception of the doctrine refer to, in particular, legislation as the paradigm example of a sovereign act within the territory of the foreign state, we respectfully submit that the principle cannot be so and should not be so contained. The territorial limits, insofar as they exist, reflective of the international legal responsibilities that go with territory, are in relation to actions of a foreign state within the UK, where, of course, very different considerations would apply.
But we're out of the realm of conflict of laws as soon as we step out of the foreign state into the realm of an extended principle which must have some different basis. Doesn't have a basis in private international law principles, does it? Or they're certainly of a different sort. It's the principle becomes yes, it's purely based on the sovereign act.
It does.
The sovereign act.
It does. It isn't confined to conflicts or private international law. It's a law. It's a principle of the kind Lord Wilberforce described, inherent in the judicial process, if you will. But it's a principle which is triggered by the need for respect for sovereign equality.
Mind you, even the internal conflict of laws principle is not real. It's not a conflict of laws, because if you extend it to executive acts, as Princess Paley, Olga, and you submit, then by definition one law isn't recognising another. One law is recognising an arbitrary act and simply saying we'll give effect to that.
Quite.
Yeah, so it's,
And one can make the same point by reference to Oppenheimer itself.
yes.
And Kuwait, to some extent. The same point can apply. Well, there is an alternative case, which is, or perhaps it was worth teeing up the alternative cases by explaining that in the Belhaj case, of course, this issue about territorial limitation has no impact on the Belhaj case regarding Malaysia, Thailand, or Libya. It applies in relation to alleged actions of the US, some of which are said to have occurred on board an aircraft, and it applies in relation to Rahmatullah, where the person, Mr. Rahmatullah, is detained in Iraq and then in Afghanistan. And again, it's some way down the line, perhaps, but there is an alternative question, which is if there is to be some territorial limitation, is that limitation properly to be characterised or cast as purely territorial, or should it extend to acts of the foreign state done in the exercise of their jurisdiction? So there's a question as to whether or not it's a pure territorial principle, or is it a principle, if there is an exception to be worked through, is it an exception which is based on pure territory, or is it an exception to be based on some rather more broad notion of jurisdiction? I mean, put it in some, I really don't want to start opening up that sort of level of complexity, and that's absolutely necessary. It may become necessary, but one can perhaps see the point quite clearly in relation to the alleged actions on the US plane. And again, I hesitate to go back over all the ghastly debates we've been having on jurisdiction and ECHR and how all that works, but you can see that it's not very difficult to cast, by reference to a whole series of rules of international law, a US airplane as in effect within US jurisdiction for rules that are referable particularly to US aircraft. But the point arises rather more broadly in relation to Mr. Rahmatullah's case and actions of the US in Iraq, where at the relevant time the US was, as you will recall from other cases, an occupying power,
What version of international law are you seeking
Well-
to invoke here? Are you trying to get some advantage out of Article 1 of the Human Rights Convention?
Lord, I've never yet been tempted into that game.
or is there some more mainstream
No,
understanding of international law that...
I mean, well, as you know, international law and Article 1 ECHR are meant to march hand in hand.
Right.
That was the entire original conception.
Right.
I simply raised the question as a possibility, an alternative,
Oh, I see.
maybe of some importance. If there, because so far the cases have very much assumed, if there is a limitation, my primary position is that there isn't, because it doesn't make any principled sense for there to be, given that what you're focusing on is the quality of the sovereign act. But if it is thought in some way, shape or form that there must be a principle that says you must restrict it, in inverted commas, territorially, there is then a serious set of questions that might arise in the context of these cases as to whether or not pure territory is the answer or some rather broader conception of jurisdiction is the answer. In circumstances where you've got a US plane, you've got US as occupying force in Iraq, and you've got US in Afghanistan with the consent of the sovereign government of Afghanistan. Well, that was the last of my topics before coming to the Court of Appeals, and I will come to the Court of Appeals 6 reasons as part of this, is the public policy limitation. You will recall that the Court of Appeal in Belhaj disagreed with Mr. Justice Simon on this precise point. This was the basis on which Mr. Justice Simon's judgment was overturned.
Yep.
The Court of Appeal in Belhaj deal with it at 114 of their judgment and following. I hope that paragraph numbering is right. Sorry, it starts at 81, public policy, and the 6 reasons I referred to start at 114. Sorry, that's MS 368.
Yep.
Is the beginning of the analysis of the public policy limitation.
Yep.
And you will see in 114 of the Court of Appeal's judgment, when they come to their decision, that they recognise that in order to get to the point they ultimately reach, they have to, quote in the first line of 114, go beyond Oppenheimer and Kuwait. The key passages of Oppenheimer and Kuwait are set out in our case at 143 to 149.
Yep.
And I make 4 submissions on this part of the case, if I may. First, the critical feature of both Oppenheimer and Kuwait is that the unlawfulness of the Government Act in question was either admitted or had already been established beyond doubt on the international plane.
What do you mean, as opposed to assumed?
Yeah, if you will, as opposed to assume, but also as opposed to dragging them into finding that as a fact. It's the clarity with which the fact on which they proceeded existed and was already made out by the time it got to this court. And if one goes, if you keep the Court of Appeal open, if you would, one goes back to UKSC in the Court of Appeal under 1 tab 3 at paragraph 69, with
respectfully submit that that is the correct principle. MS 1616, para 69. A second limitation is that, again, exceptionally, the doctrine will not apply to foreign acts of state which are in breach of clearly established rules of international law, contrary to English public principles of public policy, as well as grave infringements of human rights.
1617.
Yep.
And the clarity with which matters were established appears from the, I can take the quote from Lord Cross in Oppenheimer, from the Court of Appeal judgment in Belhaj, paragraph 82.
Yes.
Oppenheimer, for your note if you want it, but that's probably the key bit, is at bundle 8 of the authorities, tab 61. And then Kuwait Airways, perhaps might be worth taking up, bundle 6, tab 47A.
Yep.
MS 3414. And the House of Lords judgment starts at 3606. Very well. And the relevant paragraph for our purpose is paragraph 20. For the purpose of this clarity point, plain beyond argument, this seizure and assimilation were flagrant violations of rules of international law of fundamental importance, plain beyond argument, international reaction to the invasion was swift, and so on. And perhaps unsurprisingly, there was no doubt that the planes had been taken, and there was no doubt they'd been removed, and there was no doubt that was a flagrant violation of international law.
Is the test whether the facts are well established, or whether the facts, if established, would show that there had been a flagrant breach of international law or human rights?
My Lord, I think it's a bit of both, and I respectfully rely on both. And we, to some extent, come back to my Lord Wilson's point before the short adjournment about what happens if the facts are proved doesn't necessarily follow. So when one's got shades of both in there, but of course if one goes back to the rationale for the foreign act of state principle, my respectful submission is that the correct answer to my Lord's question is both.
There's no case which where it wasn't clear, both as a matter of fact and as a matter of law,
Absolutely.
That this involved, what had happened involved a flagrant breach.
Absolutely. And you will appreciate immediately the differences that exist and sound in the various rationale I went through this morning. I mean, you have no case where the court would be dragged into a determination of the sorts of issues that the court is being invited to determine here.
Will it be dragged into the dispute of law if it were legitimate for it to investigate the facts, and the result of that investigation was that there had been torture? It would then be self-evident that there was a breach of international law. There would be no controversy about that. So you have to say, don't you, that they shouldn't even get into the facts?
My Lord, I do say that, and I do say that sounds into the... And I mean, to some extent, that's the same question as the question my Lord Wilson put to me this morning. What happens if you have a set of circumstances that the court is being invited to investigate and consider, where the very consequence of finding the fact would be to lead to a clear conclusion?
So the mistake they've made here is not to allege that the facts were plain.
Well, they couldn't properly have done that.
Well, they could assert it.
Well, they could assert it, but the court...
But they'd have to assert it, otherwise they'd be bound to fail on this kind of application.
Well, there'd be a dispute if the defence said that they weren't plain. On the contrary, would
Yes,
deny
but if they
it.
were plainly plain.
They were admitted. In the Kuwait Airways case, what happened was admitted.
I'm going to come to that because my Lord, yes, plain and indeed acknowledged is
Yes.
the frame
Well,
is the phrase used in paragraph 26 of Lord
I mean,
Nichols.
I was the judge at first instance. I do remember it.
Yes, no, I spotted that. But you'll see that my Lord is right. 26 makes that clear. So 26 on page 3611, reading from the bottom, nor does the non-justiciability principle mean the judiciary must shut their eyes to a breach of an established principle of international law committed by one state against another, when the breach is plain and indeed acknowledged.
It couldn't really be anything else because the Iraqi Airways was claiming to hold them under an Iraqi law. And so they set up and said, this is the basis on which we're holding them.
Well, I think the argument looks like it was we're Princess Olga. They were taken and... Anyway, it matters not.
There was certainly an argument that, yes, the de facto they had them, but they also sought to justify it under Iraqi law. And that's
because the decree had been passed and so on. Yes. But the back end of 26, the top of page...
That had to be struck down, though, didn't it? The decree they were relying upon. They were relying upon a decree, weren't they, under Iraqi law? And then there was an issue, therefore, as to whether they could rely upon that decree or whether it should be struck down under the principle of Catamol, wasn't it?
Yes, I think that was part of the issues. But on this point...
Yes, sorry.
On this point, the facts were clear and the law was clear. I mean, if you look at the back end of 26 at the top of 3612, you've got the explanation. It is both. It's both facts and law. And the reason for that, in such a case, the adjudication problems confronting in the English court in abuse litigation do not arise. The standard being applied by the court is clear and manageable. The outcome not in doubt. That is the present case.
But if the claimants were to establish torture, how could it be an affront to US sovereignty to find that they had committed an unlawful act when American law would itself accept that torture is unlawful?
My Lord, I think the affront comes at the earlier stage. The affront comes in a municipal court in the United Kingdom, arrogating to itself the function of determining that issue. That's the problem on the international law sphere. That's the problem with sovereign equality. So my Lord is entirely right, no doubt, that torture is just as prohibited under the US system as it is here. But whether or not, which is why I say facts and law, and rely on facts and law as the explanation of Lord Nichols in Kuwait.
I suppose it's just possible that the definition of torture may vary from state to state.
It is, although I think that, in fairness, I think the definition in Article 1 of UNCAT
Oh, this is true.
would apply.
The way in which that is applied.
The present administration withdrew guidance as to what was legitimate treatment.
Yes.
Circumstances.
Yes, so there may be controversial issues about that, my lady's right.
After the Bush administration.
I was thinking more broadly outside torture, because you'll appreciate it isn't just torture. Of course. We've been addressing that as the paradigm case. We appreciate the range of allegations here, and one thinks about the facts. I mean, torture is perhaps the best example of why the controversy of facts is interesting in that context, with the legal significance probably, but not certainly, being attached and following. But one can think of a whole series of other issues that might be thoroughly controversial in terms of principle on the international plane. Take, for example, the allegations of complicity or the allegations of state responsibility that have been raised in some of the pleadings, the reach and scope of Article 16 of the International Law Commission's articles, and so on. How all of that works. I mean, a series of controversial propositions. But the short point I make is that the expression of the principle and the explanation for it, as covering both facts and law, is to be found in para 26 of Lord Nichols.
I mean, basically, in the two cases, you just had legislation and you looked at it and saw what it did, and that was that.
Well, you had legislation and you also had uncontroversial facts in the context of Kuwait. Yes. That's it.
And the same underlying thought applies to state immunity, doesn't it? I mean, no state in the world will endorse torture publicly.
But they're all immune ratione personae.
And yet it's an affront. You're not allowed to pursue it, as the Jones and Saudi Arabia case says, even against the employee.
That was precisely the issue in Jones and Saudi Arabia. It was being run on behalf of the claimant, perhaps understandably. Well, how can you possibly say that? I think they put it on the basis of the character of a sovereign act.
Yeah.
But how can you possibly say that a sovereign act is properly to be taken to include something as serious and ghastly as torture?
Yeah.
answer, said Lord Bingham, here in this case we are having to weigh up, on the one hand, the international community's approbation of and horror of torture, and on the other hand, the fundamental and thoroughgoing importance of the doctrine of immunity. We say the same balance applies, but just to prevent the same thing arising at one remove.
If torture was admitted in this case,
then it might be rather different. And indeed,
So if it's a plain case of torture, that would be enough, an Order 14 type case of torture, would it?
well, if one could posit that, I suppose, and I suppose one
Because,
could
I mean, there was a debate, I'm just looking at the earlier part of it. We haven't got the judge of first instance, well, except possibly present, but the judgments, have we, as to what the issues were there. But there was an issue about whether or not
it was a plain and obvious case.
Rule 369 should be relied upon, should be struck out, or 369, or disregarded. That's paragraphs 15 onwards of Lord Nichols's speech. But at first instance, or earlier on, that was presumably a live question for decision, was it?
I'm afraid I just don't know the answer to that. My Lord Mance might recall that.
Because we have to look at this at the beginning, not after the thing's been got to the House of Lords.
Yes, but
what the correct approach to the facts is.
My Lord, I entirely agree. But the plain and obvious, if I'm right on the plain and obvious principle in relation to facts and law, if I'm right on that principle, then it cannot be determined by reference to as it were, the presumption that arises on a strikeout, which is that facts are to be assumed, as it were. And that simply cannot be the position.
I think it's not quite that that's being put to you. What's being put to you, if the claimant comes along and goes on affidavit with details about how he's been tortured, and the only people who can answer it are the state who tortured him and they're not taking part in the proceedings, it might be said that is summary judgmentable, because there's no evidence to the contrary. What then?
Well, in some situations, one might be able to draw the inference that there is no answer from a claimant who produces, over a statement of truth, that version of events. But my submission, if I were to be faced with that...
Here we never got to that, did we? Because you said, oh, well, we'll do it on the assumption your allegations are correct. We'll have this dispute on the basis of the assumption the pleaded allegations were correct. And then you put brackets, piece number, boost number, so you didn't say it was plain enough case.
Well, my Lord, I don't think anyone's ever sought to hoist us on that petard before.
But anyway,
You're seeking to hoist them on their petard, in a way.
If I recall rightly, in Kuwait Air, there was no question of Princess Paleolga or being relevant, because the activities of the Iraqi Airways, in respect to which they were sued, were ordinary commercial activities. They were basically the use, deployment, or attempted use and deployment, and repainting and things like that, in the course of their operation of their aviation fleet. The sole matter at the sovereign level was the law, which they relied upon to justify the incorporation into their civil aviation fleet. And so the findings of fact all related actually to a purely civil and non-sovereign aspect of the case. And I think that's the reason why there were lots of findings of fact about where the fleet were and what had happened to them and whether they were repainted and that sort of thing.
But I'm sorry to need to be a bit slow. How does your plain and established beyond doubt principle work? Who determines that something is plain?
The court. The court here.
Precisely, the court here.
Yeah. but
which to that extent adjudicates on the foreign actor state.
Well, to that extent determines whether the principle is in play. What we're trying to ascertain is what are the limits of the principle, what is the shape of the limitation that applies to constrain it. Is it simply an allegation made by a claimant, which for the purpose of a strikeout may or may not be assumed to be true, or is it something rather fuller than that? I mean, one has ultimately got to determine whether or not the principle, once you've defined its limits, are in play.
You've
and
got
that
to
must
say
be
plain in the absence of evidence, haven't you?
Hello, I'm sorry.
Have you not got to say that it's got to be plain what the answer is, even in the absence of evidence? In other words, you're asking the question purely on the pleadings, on the assumption that there hasn't yet been any evidence and may never be.
Yeah. Well, that's ultimately how it will have to be determined.
That won't quite do with it, because if the defendant chooses to deny the existence of the legislation, let us say, what then? You have to put the legislation before the court, and that is technically evidence. It's foreign legislation.
But it was a defendant in each of these, in Oppenheimer and Q8, which had to plead the legislation. Otherwise, it had no potential basis for holding the planes or the
At all.
Or saying that he was no longer German at all.
But if you end up in territory, I mean, again, to some extent, it's an esoteric debate. If you end up in territory where it is clear that, and accepted and acknowledged that the legislation in question was passed, it is clear and accepted and acknowledged that the act took place, if and to the extent that acts are relied upon, and it is clear and acknowledged that the consequence of those is legal consequence A, B, or C, or A, B, and or C, then you are in very different territory. You are in territory that does not engage, perhaps to jump to the second submission a bit earlier, but you are in territory that does not engage the rationale. Because the rationale for foreign act of state is on the damage that is done to sovereign equality precisely by conducting the sort of investigation and adjudicative process that would need to follow.
How does the submission you're presently making relate to the Kirkpatrick principle about, if I can use the shorthand, incidental findings of fact? If you have a pleading which says it's admitted that if torture occurred, it was contrary to international and domestic law of every relevant jurisdiction, but it's denied that it didn't. Now, if there is nothing offensive to the act of state doctrine in simply investigating facts that do not involve as a necessary element investigating the legal responsibility of a state. On a pleading like that, all you would be doing is investigating the facts. There would be no investigation of its legality, because once the facts had been established, the admission would carry that.
My Lord, I think my answer to that is that I hope, limited the Kirkpatrick exception in that way.
You haven't.
I say that my respectful submission is that if you are in the sort of territory that my Lord puts to me, namely admit the legal consequence and deny the fact, you are just as much at the heart of the case, to use Lord Wilberforce's phrase, you are just as much inviting the court to rule on the legality in that sense, because the court will be finding the facts from which. So it isn't just a pure law-fact distinction.
It's ruling on the facts, which may carry certain consequences, but there's no adjudication about the legal consequences.
That is true, but just as objectionable is my respectful answer to that. I mean, there may be cases where it's collateral or it's incidental or it really you are genuinely restricted to that. But here we are not in that territory.
Well,
here we're
still a finding of illegality, you would say.
still a finding of illegality.
Maybe based on the admission, but there's still a finding of illegality.
Yes. And still, just to bring it back to the rationale for it, still just as problematic. Still, if not more so, just as objectionable.
Yes, I see.
Objectionable because the English court is setting itself up, objectionable because of sovereign equality, objectionable because of comity, and objectionable on the intensely practical basis that I outlined earlier, which is how on earth does the court can the court properly go about doing all of that? And again, to some extent, the limitations throw up some difficult theoretical issues of this kind, but I keep coming back to the parallel with state immunity ratione personae. You still end up in territory where that comparison becomes interesting and apt, because it is founded on the same rationale. So my respectful submission, that would be just as problematic. Can I just complete the references, if I may? It's 26 of Lord Nichols, Lord Steyne at 113, page 3632. You see in particular the final two or three sentences at the end of 113 on page 3632. In any event, In the present case, there's no difficulty in adjudicating on Iraq's gross breaches of international law. There's no relevant issue. Iraq accepted the illegality of the annexation, and Resolution 369, in agreement with the Court of Appeal, I would reject the argument based on non-justiciability. And then earlier on in that paragraph, second or third sentence by the letter D, you see the references to flagrant breach if proof were required and so on. And in any event, the Iraqi state unequivocally accepted that in annexing Kuwait and passing resolution, it had acted in breach of international law. So that's Lord Steyn. Lord Hope is at 135. Sorry, 138. 135 is the general acknowledgement of the principle. 138, it's clear that very narrow limits must be placed on any exception to the Act of State rule. And then in 140, describing the golden rule. The golden rule is that care must be taken not to expand its application beyond the true limits of the principle. These limits demand that where there is any room for doubt, judicial restraint must be exercised. But restraint is not what is needed, not abstentions. And then to the same account, 148, flagrant breach of clearly established rules of international law not to be recognised and so on. And then the third sentence of 149, the facts are clear, declarations of the Security Council were universal and unequivocal.
So you really rely on any room for doubt in paragraph 140, I suppose.
I do.
Yeah.
As being, and describing that as the golden rule, but it's all of a piece.
Yeah, no, I understand that. Yeah.
Yeah.
Yep, yep. Okay. Yep. Thank you. Anything else in
And
Kuwait?
no, I think nothing else in Kuwait, thank you. And the same point can be made, but I think more briefly by reference to the Court of Appeal's judgment in the to respondents' reliance on a Canadian Supreme Court case called Qadr. And the relevant paragraph in the Belhaj Court of Appeal judgment is 95, where they deal with that case.
Yeah.
So they effectively say there, Qadr might appear at first sight to support, but in truth they didn't need to resolve issues that would otherwise arise. So it's the same point. I referred to Abbasi.
Yes.
And perhaps, rather than going to Abbasi itself, I can take the relevant part of Abbasi and Lord Justice Simon Brown's conception of it that I mentioned from the CND case. That's in Authority 6, tab 48. Give my lady the reference in one moment. 3658 for my lady's.
Thank you.
Volume 6.
And you'll see Lord Justice Simon Brown's take on Abbasi and whether or not that involved might be stood as an example of a case effectively ruling on a foreign sovereign act. Of course, it was about American Judicial Act, so rather different perhaps anyway. But at 29, para 29 at the bottom of 3670.
Yes.
And that, we respectfully submit, is accurate and to some extent is all part of a piece with the Court of Appeal in Noor Khan's analysis of Rahmatullah. Do you remember that and their emphasis on the fact that Lord Kerr had been very cautious not to do more than identify the arguability of breaches of the Geneva Convention, and was doing so for the very specific and different purpose of the habeas application and the issues of control that arose there. So the first submission, therefore, was that it was a critical feature of the cases so far, Oppenheimer and Kuwait, that it was plain and obvious, clear beyond doubt, and so on. And the second submission responds to the question whether or not that represents or reflects a principled approach, or is it simply an incidental feature of those cases, Oppenheimer and Kuwait. And the second submission is that it is plainly a principled approach. And it's plainly a principled approach because unless one operates that as the approach, you immediately run straight into the heart of the rationale that underpinned the principle in the first place. Sovereign equality, comity, the difficulties of adjudication. And to some extent, we are entitled, I think, I submit at this point, to place reliance again on the Court of Appeal in Belhaj, which acknowledged the force of that. Yep. If you go to paragraph 89 of their judgment, NS 372, you will see 4 lines up from the bottom. Yep. It is the adjudication, sitting in judgment, examination, challenge or investigation, which is an essential element of the mischief. And we respectfully agree. Yeah. And that is why, correctly, when they came to their eventual conclusion, they said, we recognise that we have to go beyond that case law, in effect.
Yep.
And where do they say that?
I think it's 114.
Back to
114.
Yeah, 114.
383. Yep.
Central issue is whether this court should go beyond Oppenheimer and Kuwait and apply the public policy in a case where the court, if it exercised jurisdiction, would be required to conduct a legal and factual investigation into the validity of the conduct of the foreign state. And so what they eventually reason is that the public policy trumped it. And here, of course, we've got both controversy of facts of the most serious kind and controversy of law as well, potentially, at least in relation to some parts of the claim. It may be right to say, well, the consequence, subject to my lady's point about different conceptions, even of the concept of torture in different countries, but the controversy becomes real and live in relation to all the causes of action below that, if I can put it that way, at the very least. And the supporting submission for that being a correct approach in principle is that it would create a pretty radical disconnect between immunity and foreign act of state. Because on the one hand, torture could be alleged, see Jones in Saudi Arabia. Thank you very much. We're not suing them directly. We're just going to make the allegation and say that the UK is responsible on top of it, and all of a sudden the doors are open. And my respectful submission is that that is not a principled place.
That's based on Jones.
That's based on Jones.
And what does the Court of Appeal say about that? Did they address that point? The disconnect point you just made.
My Lord, I don't think they do. I don't think they address that in turn.
I mean, he refers to Jones, or the judgment refers to Jones in paragraph 116 in the passage on decision, but I don't think in this connection. Well, pick it up tomorrow. Don't take up time now.
Yeah.
I don't think he does either, but. Yeah.
My Lord, so the reason that all of that was trumped, again, as I say, I mean, up to this point.
But I think that he's saying, isn't he, that the Court of Appeal is saying that torture is a special case, isn't it?
Well, yes, but Jones was a torture case too.
It was. And I'm going to come to these reasons, these 6 reasons in a moment, if I may. At the moment, I'm simply on the point about whether or not it needs to be clear and established, law, fact, however you characterise it, the Oppenheimer-Kuwait point. And up to this point, if I've understood the Court of Appeal's judgment correctly, they're with me. As my Lord Clerk points out, it's when we get to public policy, what they then say is, yes, but the public policy has got to move with the times, it's got to change, and here are lots of reasons, 6 reasons in particular, why in this case it should be different. But all the way up to here, things are looking good, so far as the Court of Appeal is concerned.
Well, so far as you're concerned.
As far as I'm concerned. My friend Mr. Herman, I'm sure, will have 1 or 2 things to say about that. But can I come directly to public policy? The Court of Appeal's base position, if one just tracks back from their 6 reasons for a moment, because the judgment is longer and more formidable than those 6 reasons, they first of all say in 91 of their judgment, MS 374, that the English court's conception of public policy should move with the times and that there are lots of situations in which the English courts do, as a matter of fact, opine on things like this. I hope that's not an unfair summary of Para 91, but that's effectively what's being said. And of course, we do not quibble with the proposition that English public policy can move with the times. However, the public policy at the heart of these appeals is, we submit, founded, for relevant purposes, in the rationale for the doctrine of foreign act of state. The concerns recognised by public policy about courts investigating and ruling on the legality of sovereign acts abroad of foreign states. And of course, when we get to this point, we've gone beyond the Churgill argument, and we are assuming that there is a sort of general principle that I've been inviting the court to adopt today. We're now on limitations, shaping it, but we start from the base proposition that that is the approach. It applies in the way that I've indicated, and those concerns are based in sovereign equality, comity, and adjudicative difficulties of the kind I've indicated. And there has been no change in relation to any of those matters. In particular, if one looks at the mirror image of state immunity, state sovereignty, state sovereign equality, they've remained, those fundamental structures have remained in place in international law. They've remained in place alongside all the development of international law as more or less introduced into domestic law and human rights treaties and all of that. It remains, sovereign equality remains a fundamental principle of the UN Charter. There's been no change to any of that. And there's been no change to the principles governing state immunity, ratione personae. So the relevant public policy continues to recognise that one cannot sue directly the foreign state, one cannot sue its officials or agents, and one cannot do so even in relation to allegations as serious as torture, where the world has, as they point out, in some respects moved on. But the base public policy, therefore, the identification of the public policy for this purpose remains important. It's no good saying public policy has moved on, we sometimes do it, if the relevant public policy has remained constant and fixed and is still properly anchored in well-established international legal principle.
Yes, we have that. Yep.
What's the most recent European Court of Human Rights case, actually following Al-Adzani, the Germany and Italy? We got that?
Germany and Italy in the Grand Chamber. That's ICJ, is it?
It's an ICJ.
Jones in the UK following Jones in Saudi Arabia. Yeah.
Jones, I thought there was one in relation to Italy, between Germany and Italy, but in the human
That's
rights.
the ICJ, I think.
That's the ICJ, I'm sorry.
That's the ICJ, not the Audit Report.
Is that in the bundles?
Yes.
Yeah, it is somewhere.
We'll find you a reference. So the first point is that public policy hasn't moved on in relevant respects. Secondly, and to deal with the shopping list at para 91, 1 through to 6, it is of course correct that in certain circumstances, in a series of specific areas, the courts have had to examine the conduct of foreign states. But each of the examples that are given, and in fairness to the Court of Appeal, they fully and fairly acknowledged this in para 91. Each of the examples that they give may be explained as reflecting different considerations. In other words, adjudication that stems from a statute requiring such adjudication, which itself is likely to stem from a treaty where states have consented to give a level of adjudication. That's the, in particular, the refoulement, the non-refoulement principles and matters of that kind. But they exist as specific and isolated examples where, for obvious and decent reason, as they acknowledge in the sentence just before the lead-in to those 6 examples, this may be because the Act of State doctrine or rule of common law has been modified by statute, often reflecting the requirements of a treaty to which the United Kingdom is a party, or because the Act of State doctrine is not engaged at all, for example, on Kirkpatrick grounds, or for some other reason. So in fairness to them, they are not saying that these are not perfectly sensibly explicable alongside the principle for which we contend. They are simply noting, by way of context, that sometimes the court does so. But I respectfully submit that once that acknowledgement has been given, as very fairly it does to some extent draw the force or sting from a point that says, well, because we do it a lot, or because we do it in these examples, that demonstrates that there must be no great or particular problem with engaging in that sort of exercise.
Yeah.
My Lord, I was going to come to the Court of Appeal's 6 reasons, but it felt like it's been a longish day and I'm making pretty decent progress. I don't think I'm going to be longer than 20 minutes or half an hour tomorrow morning to finish off the bits that I'm dealing with. And I'm going to hand over to Mr. Phillips to deal with state immunity before wrapping up Article 6 at the end. So I'm hoping we're on schedule.
You are bearing in mind that we'd like to finish
Yes.
by the short adjournment on Thursday. You think we're on target? I'm not asking for a guarantee. I know partly how many questions you get from us, and your colleagues get from us. But
My Lord, I think so.
Okay.
And I rather suspect that quite a lot of the territory that my learned friend Mr. Phillips was going to cover tomorrow, is going to cover tomorrow on state immunity, may already have been flagged because of the commonality of base principles between them. So I'm hopeful, and we can put our heads together amongst all things overnight and see if we can come up with some new split.
very grateful. Good. Well, thank you very much indeed.
Sorry, just before you
sorry.
rise, Lord Mance asked about Germany and Italy.
Yes.
Volume 12, tab 98, MS 5666. So 12/98/5666.
Thank you very much indeed, Ms. Speedy. Thank you. We'll resume again tomorrow then at 10:15. Court's now adjourned.